boldip.com.
Hello out there. Welcome to the Bold Inventor Show. I'm your host, JD Hubener, patent attorney, owner here at Bold Patents Law Firm. Excited to be here live again on this fourth season. This is our second episode, kicking off 2025 with you all. Welcome all those new attendees, watchers, viewers, question askers out there. We're a show here going across YouTube, LinkedIn, and Facebook for inventors, entrepreneurs, business owners, brand owners, and those that are just curious about inventing. Bring all of your questions. Happy to answer anything that comes across here. Just know that while I'm an attorney, this does not constitute an attorney-client privilege. So please don't share anything confidential. If you do have anything you want to talk about, I'll be providing a link here in just a little bit for you to do that. So here's our quick disclaimer to do that. So legal notice, we're sharing legal information today, not legal opinions. Okay, so there it is written. Happy to answer any questions you've got as we go through our broadcast. And if this is your first time viewing, give us a like, shout out any questions, any comments, suggestions for content in the future. We're here live every Wednesday at 1:30 Pacific, 4:30 East Coast. You can catch us in the afternoon break, take a little walk, get some fresh air, tune in and listen in to what we're up to. We're also on our podcast. We've got Apple Podcasts, the Bold Inventor Show. So we take the audio and put it over there as well for our podcast listeners. So hello to you out there who might be listening. Our show today is talking about the USPTO. It's been in the news a lot, good, bad, otherwise, with the new presidential administration at Trump leading the way, starting things out with a lot of changes, as you probably have seen if you've watched any of the news. But if you are living under a rock, we've got a lot of new executive orders that have come to fruition here in just the first couple of days of his presidency. I want to go over some of the news. We don't usually talk about legal news. We talk about inventors and share their stories here. But today, I'm going to bring some topics, some of the issues that are coming across the current state of the USPTO, that is the United States Patent and Trademark Office. And hopefully that most of it's going to be good news. Of course, I'm going to spin it in a positive direction. I'm going to lay out the facts and the current state of the event as you see them. Hopefully, we get Matt Colseth joining us, my trusty co-pilot. He's busy, a lot of activity lately on the trademark side, and he was really busy last week before those nasty USPTO fees were hiked up. So a lot of those clients of ours wanted to get something in before they nearly doubled fees for trademark applications. So let's get to it. I'm going to go through kind of a series of updates. And like I said before, if you've got any questions, you're listening live, this is your time to plug in a question, and I'll do my best to get a hold of what you've got there. Before, as always, we get to the heart of the episode, I do like to answer some of the questions that have come in from our audience over the past week. And so let me just pull those up here. All right. Thank you to Mia here internally at Bold for gathering these questions, by the way. She does a fantastic job mining our Reddit page as well as our Quora page. So here's a question regarding a patent. Which type of patent to pursue? And here's what I think we handled that one perhaps last week. So make sure we don't double up on that. Yeah, we did that one last week as well. Well, we've been answering a lot of these questions. Here we go. This is a good one here about licensing. Okay. All right, there is a patent guru. What, me? I guess there's some other guru out there. There's a patent guru on YouTube who's claiming if your goal is to license your patent, all you need is a provisional patent. And getting a full patent for that purpose is a waste of time and money. Agree or disagree? Well, I disagree. I disagree on many fronts. I have a hunch as to who I think this guru might be. And I think they're well-intentioned. So don't get me wrong. I'm not slandering anybody here, nor am I going to name any names. But I will say that if your goal is to license your patent, you need to actually get a patent. Okay? So to get a patent granted, you do have to file a non-provisional, or i.e. the full patent application, which will then get examined. The USPTO examiner does their own search, gives it that thumbs up, which is known as the notice of allowance, and then you pay the issue fee and get the actual federal rights granted. That's when you get the patent number and so forth. That is what is being transacted in a licensing agreement. Now, there are licensing deals that can happen with pending applications, but that word application is really vital. In this question, I'm concerned already because you're asking, all you need is a provisional patent. There is no such thing as a provisional patent. There's a provisional patent application. And a provisional patent application is one that's less formal, doesn't require a lot of the rigor around the declarations, the disclosure of invention or known prior art, as well as the detailed description of drawings and a lot of the figures and the claims being in the specification. It can really just be a description of your invention, and you can include drawings if you want, and they can even be hand-drawn. They don't need to have any specific format or function. And so it's quite easy. And a lot of inventors will be able to learn enough about patent law to be able to file a decent provisional on their own. And so for a lot of bootstrapping entrepreneurs, I think it's a great option for you to file something. It's better than not filing at all. And that's what the USPTO, the Patent Office, and the policy would actually prefer. We want innovators, inventors to tell the world, right, to file your application as soon as possible. That's why the law changed about 10 years ago. It's no longer whoever invents it first, it's whoever files it first. And so we want to reward inventors to file. And so that's why the bar is really low in terms of the technical competence and sophistication needed to file a patent application at the provisional level. But the problem is there's no federal grant. You have no rights that are granted when you file a provisional patent application. So it's really vital that you understand that. Whoever this guru is, I hope that they're clarifying it. The fact that you're asking this question in this way tells me that maybe they're not hitting that home, that you don't get any rights by filing a patent application. It's pending. And a provisional does not even get examined. So it really is just this placeholder. You could file a provisional application that says, "Hi, I'm JD." And that's the entirety of the spec. You would get a pending application number, but there no one or no company be willing to compensate you, the inventor, for that statement. It doesn't describe any invention, and it's not valid. So long story short, there are certainly ways to get patents licensed, but in order to get a patent license, you have to go through the process of filing a full patent. So certainly not a waste of time. That is how patents are granted. So I would disagree with that. Let me try to tackle a question on the trademark side, and I see a couple of people have joined in. If you have any comments or questions, topics you want me to handle, this is the time to do it. I'll get you to the front of the line. I want to answer a few more questions that came in through the week, and then we'll get to our topic about USPTO fees in just a few minutes here. All right. So here's a question here about this one. This is a buying and selling real estate and patentability. All right, so here we go. I've developed a novel approach to buying and selling real estate, and some software tools assist the process. If the concept or business model is patentable, it'd be great to have patent protection, but I don't want to spend a lot of time and resources if it's likely to succeed. Any advice would be appreciated, and if you have recommendations for a provider, that would be helpful as well. Well, I do have a recommendation. Get a hold of us at Bold Patents, schedule a free discovery call, and we'll be happy to kind of guide you along this way. Business methods, which is what this sounds like it is, would definitely qualify as an eligible patentable technology. Matt, good day, buddy. Good to see you.
What's going on? How are you?
Doing good. I'm hacking away at this question here that came in. You're welcome to kind of come up to speed. Thanks for joining in.
Sorry, I'm late. Got bogged down, and when I looked up, I was late.
It's all good. You're a busy guy. It's awesome. Good to have you. So we're talking about this question about regarding real estate
Yep.
So we've got some software or business method they've come up with about assisting the process for getting buyers and sellers to transact.
Cool.
And so they want to move forward and see if that's patentable. I said, yes, indeed, business methods are patentable.
Sure.
As long as you've got a novel, right, the first of its kind, series of steps. And if you're putting together valuable, technology, you're just able to get that data put together in a faster, more efficient way, identifying the right clauses, right? Lots of different ways smart contracts are put together. It's definitely eligible. So get a hold of us. We'd be happy to kind of help you think through that. One thing about business methods, I will say that can be challenging, and we always want to check with inventors about, is there's a risk of non-detectability, right? With software, business methods, these types of inventions, even if you are able to get a patent secured, it can be challenging to identify infringers.
Sure.
How will you know from the public vantage whether your invention is being infringed? So it's something to think about. Maybe you've got a good idea, and if you do, I'd love to hear it. So it's kind of part of that. Hey, we can get you a patent on it, but we want to make sure we're helping you from a holistic standpoint. Do you have a business plan? Is there a real ability for you to identify, leverage this technology, or maybe it's better kept as a trade secret? So that's one thing I wanted to mention there. Pat, any comments on real estate?
No, super cool. Real estate's interesting. They're always hard to file and register because there's so many folks in the financial services and real estate sector at the USPTO. So this would probably fall under both real estate services and maybe some sort of computer or SaaS PaaS services.
Yeah,
cool.
Got it. Cool. Well, we didn't have a whole lot of questions. I was looking through these and I almost brought up the same question as we did last week.
I can answer differently.
I did find one new one on the trademark side from Reddit. And again, I welcome any questions from our community out there or any of our live viewers. Here it is right here. So this is I think it's about mailing. So hey, everyone. For a trademark in the U.S. under my personal name, will my domicile address be public record, or only the mailing address will be provided to the public? Can a mailing address be a P.O. box? I want it under my personal name just in case I close my current corporation in a year or two, but would like to have ownership of the mark. Could I use a Google Voice number, personal number to avoid people having the personal number be published? What are your thoughts on this, Matt?
Yeah, this is a great question. Get this all the time. So, yes, there's a difference between your domicile and your mailing address. You always have to provide a domicile address. It doesn't matter who you are, corporation, individual, you have to provide a domicile address.
Okay.
If you don't provide a mailing address, your domicile address will be your mailing address by default at the USPTO. Okay. So when you're filling out the form, if you want to hide your house address, right, you'll enter your house address in the domicile position or portion, and then you'll click a box for the mailing address and you'll enter the mailing address. And that can be a P.O. box. But of course, your domicile cannot be a P.O. box.
Okay. A lot of words, but that's important. So the clarification is the domicile address, so long as your mailing address is different, your domicile address will not be published.
Correct. Right. Okay. And the USPTO has gotten very good in the last 5 years of sniffing out P.O. box domicile applications. So they must have access to some pretty good tool because every single address that comes through that's even remotely similar to a P.O. box or post office, UPS, FedEx box, whatever, they know about it. And they'll basically issue an office action saying that that's not the correct address.
Ooh.
And what's really interesting, there's been so many updates at the USPTO the last month. It's been absolutely mad.
That's what we're talking today. We're talking USPTO news. So
yeah. I'd like to get a hold of that director, man. Things are really falling apart here. But what's interesting about it is that, now if there's any issues with the application, so for example, like say we submit an application where the domicile address is actually a P.O. box.
Okay.
They're going to find out about it, push back on us, and they're going to charge us an extra $100 now. That's something that they haven't done in the past, but I mean, just today, because typically what we would do is we file these applications and, we want to push the USPTO as far as we can push them in terms of our clients' rights and, expansiveness of the goods and services. But now if the USPTO has to respond at all to us, they're basically issuing a $100 fee.
Wow.
I
So
know.
they're making you refile it in a way, right? They're making you.
Yeah. They're not making my job any easier. That's for sure. I think that, and combined with a lot of the junior trademark examiners now, it's not great. I was just complaining to my wife a little bit earlier today about it.
Well, this is your time to complain, Matt. The topic is USPTO fee hikes, impact on inventors and brand owners. So I had a couple of topics teed up here.
Yeah, it's frustrating is what it is.
Yeah. Let's start with the money. Let's start with the fees, kind of across the board. I'm talking, so let's talk patent office fees.
Yeah, we'll talk patents first. We'll talk trademarks.
So patents, I think it was, we'll call it a bit more of a modest increase. This is the first increase since 2020. Okay, so I guess that's something. 4 years, not a ton of time. It took effect January 19. I think it's the same date on the trademark side.
Yep.
7.5% is basically the fee increase. A couple of little points here to make. Probably the biggest felt increase is on continuation in part and continuation applications. Huge increase, $4,000 increase.
Wow.
This is to sort of capture, honestly, it's probably just to get a lot more money from the bigger companies that keep filing more and more child applications to try to, continue the life of an app even after it's been, expired. So yeah, really increasing the price. It's a shame here because this is really the key way for patent holders. If you get that parent filing granted just before you issue, we typically recommend a child get filed in case what you're selling changes over time or competitors try to design around it. You can try to match what your competitors are doing to continue to sort of broaden that scope. That's going to be more challenging because it's going to cost more. And it sort of seems awful because the lift isn't that much bigger. It's kind of just a grab. So that was one of the bummers. I don't mind a 7-8% increase, with respect to inflation and coming up to speed. But that's kind of the really high level patent fee increase. We can obviously quote specifics and if we have time, but I wanted to talk trademarks. I think there was a much more substantial increase.
There was.
Yeah.
Let me see. For some reason, I want to say like the USPTO was saying that, yeah, it's about 40% increase in fees.
Okay.
Which is pretty wild.
Yeah, that's big. And so basically, it was 250 going to 350.
Yeah, it was 250 prior to the 18th, and now it's gone to 350. And then they've increased a bunch of other fees too. So some interesting ones that we can talk about really quickly. And I will say at the beginning, like, I've been doing trademark registration for the last 13, 14 years. This is the first big increase that I've seen in my career. So, at the end of the day, yeah, it's a significant increase. But realistically, compared to the rest of the world, the United States still offers a pretty good value for money from the trademark perspective. England, it's like $1,000 basically, right?
Yeah,
so
right.
350 is not so bad, I guess.
I was talking with someone. I always do quite a bit of networking, and one of the individual attorneys I was speaking with, they do a lot of filing in UAE.
Yeah. Oh God.
Emirates.
That's like $2,500 each.
Yeah, you're right. I was blown away.
It's crazy.
So it's not like we're quite at that crazy level. We're still in the hundreds, thank goodness.
Yeah.
And perhaps this is going to be the.
Well, I mean, I will say, like, if these fee increases get us some better service from the USPTO, great.
Yeah.
Then it's well worth the increase in fees. But if we continue to get the same substandard response times, turnaround times, office action analysis, people are going to be upset about it. At least I'll be upset about it as a practitioner.
Right.
But some other increases that are interesting. Basically across the board, everything is up, but they've added some additional fees, which are interesting to me. And I'm not necessarily opposed to some of these. So the insufficient information fee. So if we submit an application to the USPTO and they find that, we're not as thorough as we need to be, or they want more specificity.
Specificity. That's a tough one.
Usually that's not a tough one. It's weird. Well, if they have to come back to us, essentially, they're going to charge us $100 for that. And that could happen multiple times. So that stinks for clients.
Okay.
And then a lot of times for clients with really unique products and services, we'll do a free form goods and services description. So we'll think about how we want to frame up what they're doing, and then we'll type it out in as broad a possible way as we can. But USPTO is going to charge an additional $200 now for that luxury.
Yeah,
which is a lot of money. And then this last one I kind of really like. If you do the freeform text box and you have over 1,000 characters in that text box, the USPTO starts charging you additional money. And what I like about that is it's going to disincentivize applicants from like doing the kitchen sink approach, where they just put everything in the application.
I guess that is good. Yeah.
So that's good. Post registration fees have gone up pretty significantly, a couple $100. Petitions to the director, that one's gonna hurt. That goes from $250 to $400.
What's a typical petition? What are things that you might be asking for?
So a petition to the director would be typically it's going to be like after you exhaust your office action responses. So you get your preliminary, then your final office action. And if you're still unsuccessful after the final, then you can petition the director to review the application.
Okay.
Petition to revive an application. That's probably the most common one. Either a client doesn't necessarily get back to us and want to respond to an office action right away, or we miss a deadline because the client's dragging their feet or whatever. The petition to revive the application goes from $150 to $250. So
got it.
We're spending more money, and I hope we get some better results as a consequence. Because right now, we're sitting at, I think, 9 months, 8.5 months from application to initial examination, which I don't know. That is not acceptable in my view.
Yeah. On the patent side, there were some new fees as well. I'll go through a few of those. So sure. The IDS, which is the information disclosure statement, this is what is required to be provided at the non-provisional phase. This is when you as the attorney and the client, you've got to give all you know to the examiner. It's a requirement for you to share. If you did a patent search, you have to tell the examiner all the results you found. And it helps them expediates the process.
I'm giving it to you.
Man, well, so it's contagious. A lot of things are this year. Hopefully, there's a lot of getting sick. So, kind of a good news, bad news. If you've got a lot of disclosures to make, now you got to pay for it too, which kind of seems a little bit sad. So 1 to 50, 1 to 49 is free, but 50 to 100. $200, you provide more than 100, it'll be $500 more. So if you throw a lot at the examiner, they're gonna be charged for it. And then we were talking about before, the big new one is this continuation app. There is some clarification here. Yeah, so I want to make sure I know it isn't just any continuation, any child. So if you have that parent and it's getting ready to issue, you can still file that continuation. There's no additional fee, but it's the after 6 years of the earliest benefit date, and you're still trying to file another child, it's $2,700 after 9 years. So if it's been 9 years since the parent's been filed, your earliest benefit date is $4,000. So those are brand new fees, basically charging you additional sort of a premium. Things must be going well with your priority date on your initial patent, so give the patent office just more money. It's the same amount of work, but share the wealth in a weird way, which is interesting. So that part I don't love, but I think it's going to mostly affect, larger entities that have portfolios that they're reaching back on, and then just more drastic increases. 100% increase on claims. So just when your claim count exceeds 20, it's now not $100; it's $200 extra. Mm-hmm. So that's more than the 7-8% that they were quoting.
Yeah.
Patent term extensions are going up 119% from 1,180 to 2,500. And a few other things are a bit higher than what they stated. So these fees are coming together. And like I agree with you, I do hope it comes with more efficiency that'll lead to more timeliness. We've gotten kind of used to on the patent side a year, especially for busy art units, AI, technology, software-based innovations. It's just going to take several years. But I'll just see that kind of come back toward the norm. And
Yeah, it would be great. I mean, for years when I was a younger attorney, 3 to 4 months was pretty standard from application to first review. That's no longer, because it's really hard to tell a client, registration is probably 14 months from now. What?
Yeah.
That's crazy. Nothing takes 14 months.
Oh, okay. We're going to keep fees as sort of our top topic, but this is sort of a next in line news, with our new president in office, a lot of new executive orders being issued. Big mandate here, kind of across the board, all federal employees, butts in seats. So no longer really allowing telework. There's the IP article. I subscribe to Law 360.
Oh, cool. I haven't read that one. I was curious about that, though.
Yeah. So basically 50% are teleworking right now.
Yeah.
And I don't know the difference between teleworking and remote. It's ridiculous. But to me, they're about
the same thing, right? It's the same thing.
I don't know, actually. I think they're actually termed different. So telework might mean that you're, part-time. You're sort of hybrid. So telework means hybrid. Virtual means
interesting.
100% virtual. I think that's the terminology. So either way, there's a phased approach, but they've all got to get back in some physical office. And I don't know. Do you think that's going to make people more productive? It's kind of a bigger question of, are we more productive at home versus in the office, or vice versa?
Yeah, that's a good question. So, at least on the trademark side, most of these examining attorneys are working from home.
Right.
They're just like us, right? They work from home office or whatever. But there's so many younger attorneys now working for the USPTO, and my sense is they just don't have the training or experience necessary to really do a good job. So, I mean, it's not so bad from my perspective if folks have to, go into the office and have a little bit more supervision in terms of the work they're producing. But yeah, I don't know how you do that, because there's got to be close to a couple thousand attorneys who work for the USPTO.
Right. Well, and I think a good distinction here is not everyone knows that on the trademark side, the examiners must be attorneys. Right. Whereas on the patent side, not at all. No, they may be attorneys, but it's not required.
Interesting. I didn't know that. I assumed that they were all patent attorneys.
No, examiners pass the patent bar, but they're usually, they've got some time in industry. They have a science degree. Then maybe they have, some acumen within that what's called an art unit space with a particular area of innovation. I think very few are, Juris Doctorates. So it is quite a distinction.
That's interesting. I didn't know that.
Yeah, and I've always wondered why that is. In office actions, right, where we get an examiner rejection, we oftentimes will come back with legal argument. We're making legal arguments to non-attorneys. Yeah,
individual.
Yes, so that we're working with more of a technologist, right? Sort of a CTO.
Okay, that's interesting.
Mm-hmm.
Yeah. What are your thoughts with this article you read? What did they say about?
Well, the USPTO has made teleworking part of its culture, even before this larger cultural shift, post COVID-19.
Yep.
The agency's website calls itself a model for telework in the federal government, and so this is kind of a reversal of that, of now mandating. And I'm quoting this here: the edict could impact the entire federal workforce, 3 million people total. Of course, that's all federal employees.
Sure.
And that's a statistic from the Federal Reserve Bank St. Louis. According to the brief missive, agencies and departments must take all necessary steps to end telework arrangements and require employees to work in person full-time rather than hybrid agreements. Heads of agencies have some wiggle room. They've got exemptions when they're necessary, but it seems like it's, 6% of all federal employees are working in person right now, which I was staggered by. It's only 6%.
6%?
Yes, so 94% are currently remote.
What?
Yes. Yeah, currently about 6% of federal employees are working.
Well, there's your problem, buddy.
Whoa. So there's a whole lot of.
Hey, you know what? I'm all for the telework and stuff like that, but you can't tell me 94% of people are cut out for,
Yeah.
virtual work. They're not.
Yeah.
I'd say less than half the people that I know, who are professionals are really qualified to be working from home and responsible enough to do it, right? Certainly not 94%.
I would say I agree. I hadn't actually read that top line. So yeah, it's a big stat. 6% is incredible. What in the world? So a little more, a little more supervision,
Some supervision,
accountability, and just maybe a bit more cracking of the whip, right?
Yeah, no, it'll be interesting to see what the Trump administration does with everything. I mean,
Yep.
I'm not super connected. I don't keep up on the day to day of the USPTO, but I know Trump is really big up on getting rid of all the DEI initiatives, diversity, equity, inclusion. I'm not sure the USPTO has participated in that or not. I don't know if they have their own programs. I assume they do, but
Right.
yeah,
Right.
I don't know how many of those examining attorneys came through that program at the USPTO, but my gut tells me quite a few.
Yeah. So we've got quite a few changes going down. I think that's the biggest one. So I think maybe with fees going up and office workers returning to office, we might get some more efficiency. So that's something I think we can hope for.
We'll see. Because I know that at the USPTO, a lot of the day-to-day operations jobs, processing mailings, the assignments bureau, all that stuff, I believe, is in person in Washington, D.C.
Yeah. Okay.
At the USPTO office. But I don't know how you get all those examiners to show up to work in Washington, D.C. when they all live
all over the world. Else. Yeah. Well, there's a new acting director. So last year, the director stepped down.
Did we ever figure out why they stepped down?
There was very little said. Very little said. It came right after the election results were in. So I think it was just perhaps a political decision.
Okay.
For
I heard they resigned, right? But
it was a resignation. Yeah.
But I hadn't heard anything about specifically why.
Yeah, it's Kathy Vidal. She stepped down, I think, in November or December, I think. So Koki Morgan Stewart, she's the acting director. She actually was acting, interestingly enough, right at the beginning of the Biden, what do you say? Presidency,
administration or whatever,
and so apparently she's interim.
So she was the previous administrator working.
Previous interim, yep. And so I assumed they're working. Trump's administration is working to name a new director right now. But she took a break from her senior counsel role at Melvany and Myers LLP. The I'm reading this article as kind of remote work. We talked that artificial intelligence is interesting. One of his executive orders, Trump rescinded the Biden administration's 2023 AI. This is Security Innovation Using AI standard. And the order had required the USPTO director to issue guidance to examiners about inventorship in AI, including generative AI and other considerations. So it's kind of this additional requirement and layer for more guidance regarding AI that's no longer in place. So that's been rescinded by the Trump administration. And so maybe more, allowing more AI-related inventions and perhaps being a bit more lenient on what can come through. So that's, to me, that sounds pro-patent. But also could mean less guidance, a little more work perhaps on the back end, right? So
I felt even on the trademark side of things that if there was artificial intelligence in those goods and services descriptions, it's gonna get slowed down, inevitably. I don't know if it might be a separate, hoop, but it seems slower to me whenever we file an AI application.
Yeah, well, I think obviously AI is going to impact a lot of every area of IP. Copyright, I think, maybe is the nearest, and some of these particular, and one of these, I forget the case, but there's these deep fakes, right? And the Copyright Office is saying that there's an urgent need for legislation addressing AI-created deep fakes, where they honestly cannot tell whether it was human-made or not. Very fascinating. I don't deal too much with copyright really at all. We're still pretty focused on patent works. Do you see that, or have you heard anyone deal with it? some of that type of
I
concern?
I haven't heard too much about the AI in terms of like copyright filings or how that's gonna impact things. Certainly, like, I talk to clients almost every day about them using AI in their business, right, and how they're using it or how they're using it for marketing or advertising or branding. That's a big one. Folks use AI now for branding purposes, whether it's
Sure.
logo generation or coming up with a list of potential names for their goods and services. I don't have any real concerns about the naming convention side of things, but the jury's still out on like what can you do with the logo, right? Who owns that logo, right?
Yeah, that's artwork, right? The artwork itself you're talking, or you're saying
Yeah, right. So like you don't own the copyright. If you have a AI generate a logo for you, you don't own the copyright. Do you own the trademark though if you use it?
Yeah,
Probably.
I would lean toward yes, right? It's
So
them.
yeah, because they have different public interests. So yeah, I mean you can use an AI generated logo for trademark purposes, but you can't register as a copyright.
Yeah,
And
that's really good. Yeah, trademark being what's that? Source identifying, right? As long as it's doing that main function. Who cares?
I can't help but think that a lot of these there's so much AI generated stuff out there right now, content, right, that people are using, making money off of.
Yep.
It seems to me that a less than reputable company who is creating all this AI generated content for third parties, right, might come back later and say, "Hey, we actually own that, right? That's ours, right?" And pretty easily be able to digitally track and trace.
Oh yeah.
The use of that those creations, right?
Yeah.
So that's my biggest thing with clients is like, hey, like it's the Wild West out there. I don't think I would at this point jump it all in on AI generated content for my own business.
Yeah, it seems like it'd be worth it, to pay the designer on Fiverr, $500 and just be done.
Yeah. Go on, 99 designs, get one for $200, right?
Exactly. No questions asked. I paid for this on this date. It's mine. Anyway, that'd be my quick take. Don't save that $500 necessarily. Cool. Well, a couple of cases I guess we could bring up here. There's a lot of different cases all over going on, but I did find one with Walmart. I like to hear that Giants getting having to pay up. So Walmart settles one of their footwear cases. Company named Deckers. You probably heard of Deckers, kind of a bigger company versus a whale of Walmart.
Deckers Outdoor.
Yep, Deckers Outdoor Corp. They own UGG, UGG and Hoka and Teva footwear. They were successful. Obviously, we're not going to be privy to the settlement, but it looks like it's going to completely resolve and the case will be dropped. So Walmart pays out. It was interesting. So a little bit of a combination, both trade dress and design patents. And I want to take a couple minutes on this. We've always kind of wanted to talk about.
Oh gosh, yeah, this gets
murky.
The weeds are growing right now.
Yeah,
so we're about to get in them.
So yes, we are. So let me show off a little bit. This is the design patent at issue.
Cool. Yeah, and then for those listening in their cars or at home, this is probably one of the most like challenging distinctions to make, at least in the IP, in my mind, in my small little pea brain. The difference between like a trade dress application and a design patent, right? And we'll talk about the differences, but they look the same from a drawing perspective.
Right. So this is so Deckers has got this brand. This is sort of the Jennings or the fluff, yeah.
Oh, I don't know this one.
Kylie Jennings. Anyway, so it's a popular pop artist, sort of a signature shoe, and Walmart had a very similar Bad Piggies.
Oh, interesting. I don't think that in my mind that doesn't violate copyright.
Yeah, well, trade dress, right? So
I guess it depends on what was claimed in the trade dress or the design patent, right?
Yeah. So this is maybe it was close enough to scare Walmart away to settle. But this is design patent. It's a design patent with the D right there, and the claim being just the ornamental design. That's really all you own with the design patent is the shapes here, and you can see in solid line this concept here. You can use shading, but all this is claimed. And I do see 4 distinct puffs,
I do too.
as opposed to 2 on that other one.
That's not claimed as a feature of the patent, is it? The 2 or
well,
the 4, is it?
Right. No, what is claimed though is all, this is all part of the claimed elements. Yep.
Okay.
Yeah, I see some dash lines here on the sole, but that could be stitching. So there's really no environment here. But it does show some aperture. See these dash lines here. So those edges are not being claimed in dash lines. But all the shape is being claimed.
Cool.
So that's part of the fluff, shoe. And there's a whole other line of UGG. So trade dress. So go ahead.
My gut check for me is that's not a violation, at least in my mind. There's only so many ways to make a shoe, right? And so many different materials to use in a shoe, and that to me doesn't seem like a violation of either trade dress or patent. But what do I know?
Well, for design patents, the rule is still with the Egyptian goddess case, which is the ordinary observer. Would an ordinary observer think that that's the fluff shoe? Apparently, it scared off Walmart to want to settle. So I kind of agree. There weren't a lot of similar elements there.
So do you want to talk about trade dress versus patent or design patents?
Yeah, let me talk. So let me cover designs, and you talk trade dress. So design patents cover visual, non-functional characteristics of an article of manufacture, and it relates to the configuration or the shape of the article. It ultimately protects just that appearance, not its structure or functionality. And so to determine if it's ornamental, the USPTO will look at design alternatives, different angles, views, and the particular design, can include environment. It's not claimed, but it is just that article of manufacture. And the whole purpose is to prevent others from being able to make, use, or sell articles like that, look like that, completely apart from what it does. So if the design includes anything regarding function, it's excluded from the infringement analysis. So let's say it has, obviously your foot can go in that shoe, but you're not going to be able to get protection for a foot covering, if that makes sense. It's almost like a piece of art. It's separated from its functionality. Design must be an article of manufacture. And of course, with design patents, like any patent, it has to be novel and non-obvious. So there can't be any other shoe or invention like it ever been published, not just published in the world. And that exact shape can never been done before. So that's design patents. What's a trade dress?
Yeah, it is the ugly cousin of design patent. So both design patents and trade dress essentially protect the same thing, the look and the aesthetics of a product, right? But they go about it in slightly different ways. Whereas the design patent is limited kind of to what's claimed in the application. A trade dress application can be broader in the sense that if something presents a likelihood of confusion based on all the factors, likelihood of confusion, then that can be a violation of trademark or trade dress. So it's a little bit easier, I would think, to prove trade dress infringement as opposed to design patent infringement, unless it's just really clear from a design patent perspective that it's a copy, a one-to-one copy.
Right.
Trade dress, in order to get a trademark trade dress registration, the trade dress itself or the look and feel of the product cannot be functional, but also more importantly, it has to function as a trademark. It has to, when people see the design of the product, they have to immediately recognize the source of where that product came from. So for a smartphone, the notch or the whatever you call it, right? Everybody knows that's Apple, right? And that's part of their trade dress application. I'm sure they have one. They probably have a design patent on it as well, right? Because you can kind of go after two different infringers depending on the facts if you have both of those. So, yeah, interesting. I've only done probably a dozen or so trade dress applications in my career. They're pretty rare.
I think
they're notoriously difficult to register. So,
yeah, and I think with another big sort of difference is trade dress. Correct me if I'm wrong, Matt. You do have to demonstrate that it's being used in commerce.
Correct.
Whereas design patent, you do not have to do that at all. There's no obligation to show any commercial. You can just have it be sort of in stealth mode, if you will, or
good point.
You can wait 5 years to bring it to market.
So an example of this is I have a client that I filed 4 different trade dress applications in the last couple of months to protect the outside look and feel of the building that they're building and the inside look and feel. It is going to be very difficult to convince the USPTO that the drawings that we submitted, the sketches that we submitted are ultimately going to match what's actually produced by the company, right?
Yeah.
That's the goal, but the USPTO could very easily come back and say, hey, these don't match. This is not the same thing that you submitted, right? In which case we'll have to refile everything. But,
yeah. Got it.
Yeah. I don't like doing intent to use trade dress. That's kind of what we're doing. And
right.
It seems like to me that that's a difficult hill to climb. But we're going to try to climb it because it's important to the client.
On infringement or a trade dress infringement, is it the same analysis where it's likelihood of confusion?
Yeah.
Okay.
So like an example of that would be, I have a client that we're in the midst of fighting for a trade dress application on a cake style.
Okay.
So she's developed a cake that's covered in sprinkles, calls it a dot cake. Kind of went crazy, went viral, 5-6 years ago, I think.
Yeah.
And it's been copied a lot by other people who are kind of copying her look and feel of her cake. And so we filed the trade dress application, initially denied. We're working through it. But if we can get the registration through, then she can go and enforce the trademark and tell people to cease and desist using her style of cake.
Cool. There you go.
I mean, it's a big lift for sure, but I mean, she's got a good argument. So we're prosecuting the case at the USPTO.
Love it. Well, good. And that's at the T tab, correct?
So this is still at USPTO.
Oh,
so this is still
the
examination. Yep. And then, ultimately, if we're successful, then we would, try to probably prosecute some trade dress infringement against the, I guess, most obvious infringers.
Yep.
So
very, very good. All right, Matt, you ready to do a bold bite here of our last segment of the episode?
Let's do it. My kids are super into Shark Tank now, by the way.
Oh, good.
We were in Carmel the last week or so on vacation, and they watched a lot of Shark Tank on that trip.
Well, maybe this is one. This is actually a couple years old, so I don't think, unless they're watching an older episode.
No, I don't think so.
All right, let me open this up here. Switch our audio over. Is actually one of the person pitching his second time.
Okay.
To Shark Tank. All right. Gotta share screen. Okay. There it is.
Shark in the Tank is a new take on an old tool for artists.
Hello, sharks. I am here pitching a business with millions in sales. Better yet, my business is built around my invention. But the most amazing thing of all... Oh, I'm sorry. Hold on.
Are you okay?
It's gonna be... Oh, this is embarrassing.
Well, thank you.
Remember? I passed out here once.
The most amazing thing of all is this isn't even the first time I've been on Shark Tank. Oh. That's right, sharks. It's Les Cookson, the car sick bib guy from season 2.
Yeah.
Back again. Here's a little reminder. The car sick bib is the smart, hands-free barf bag for kids.
It's a bib.
It's a bib. It's a car sick bib.
It's a feedback, too.
Then, when it happens...
Oh.
Don't worry, because this time, I'm not pitching a vomit necklace. I'm took that invention behind the barn and shot it.
Yeah.
You're welcome, Mr. Wonderful.
Thank
But
you.
I took what I learned from watching Shark Tank to grow one of my other inventions to massive sales. So Sharks, I am here asking $300,000 for 10% of my business, Lucid Art. At Lucid Art, we sell the Lucy drawing tool that can make anyone an artist and any artist a master. Set whatever you want to draw in front of the Lucy, look down to the viewing window, and draw over the reflected image to start your masterpiece in minutes. The Lucy is my reinvention of a classic art tool that has been used by artists for centuries. That's right, the old masters had help, and now that I've breathed the new
Observe,
Yeah,
Lori, how
let's
easy
see.
that was.
tracing paper, it actually involves a little more skill, involves a more practice.
Well,
But
obviously,
obviously, the first time you do it, you work with it for 30 minutes, you're gonna be drawing things like you've never imagined you could draw.
do you have a patent?
I have a provisional patent on this.
But you said it's been around for a long time.
I'm sorry, on the improvements. And so the historical device, it had a lot of issues. It's the reason people stopped using it. The image was small, it was unsteady. And I spent 4 years tinkering in my garage, making it working and making it new again. So it's something that artists want to use
So
again
this is for
today.
either artists who already are, serious about it, or someone who really wants to take it serious.
So 20% of our sales are to people learning to draw. 20% are professional artists who they can actually draw just as good without it, but it speeds up their process. And in the middle there, that 60% in the middle are people who are amateur artists who just want to learn how to draw better.
So you were here before with that device.
Yes.
You took it out behind the barn and shot it.
Yes.
Why did you get into this? Yeah. What has happened since then?
I've been an artist and inventor since I was a little kid, always drawing designs. In my early 20s, I was going to school, and my teacher had brought in the historical device into class, and I was so mesmerized that something so simple could create that image. And he started talking about the problems with it, that it doesn't work very well. So I spent 4 years tinkering in my garage to make a design that was something that was way better than one has ever been before. Then I went from the inventor in my garage to the entrepreneur trying to sell this thing. And I hit a roadblock in like 2010. And so I got sidetracked with a few things, including a bib that you barf in that actually ended up on Shark Tank.
So
with.
Les,
Yes.
what do you sell it for? What's it cost you to make? What are your sales in the last 12 months?
Okay. So the Lucy Flex, that's going to cost them about $128. It costs us $25.50 to make it. Past 12 months, we did 2.3 million.
Wow.
What?
I told you millions right at the beginning. Do you think I was lying? Come on.
No,
I
wait.
lied to an old friend.
That's impressive.
That's
Did you
amazing.
make any money on that?
Last year, we did 3.7 total, and we made 1.6 million profit.
Wow.
And what have been your lifetime sales?
10 million.
What?
$10 million.
$10 million.
Oh,
So let's break down who you're selling to.
Yeah.
So you're selling direct to consumer,
95% is direct to consumer
95%.
from direct consumer from our website.
And how are you getting people? Are you doing Facebook ads,
Yeah.
Instagram ads?
What works best for you, Les?
Well, YouTube is really good because people who are going on YouTube and they're going to watch a drawing tutorial.
Right. So they're
Yeah.
typing in how to learn to draw. They're spending
Exactly, yeah.
time.
How much are you spending on advertising?
Last year was a big year. We did about 70,000 a month in advertising.
Wow.
From watching Shark Tank, every time I saw an entrepreneur come in with these awesome numbers, they said social media was what was driving it. And so I sat down and actually spent hours watching videos, learned how to do it. So then the advertising started taking off in 2018. When I did that, $1 million.
The 300,000 or 20%.
So, I mean, I think I came in with a pretty reasonable evaluation. Would you for 12%?
Let me paint the picture for you.
Uh-huh.
That's exactly where I wanted to land. Gotcha. Thank you.
Got a deal with Damon.
Nailed it. So that was cool. Man, riches in the
Well,
niches.
story here. This is, not a new concept. Switching microphones here. The original Lucid drawing system, 1806. 1806 is the original inventor, which is way back. Patented the English chemist William Hyde Wollaston. It's where they can make replicable drawing tools, optical toys, and so it's a way for those artists back then to be able to use that. So really, just improving using technology. So he did say he filed a provisional. I couldn't find any granted patent, but obviously he's had a lot of success selling his product, being perhaps first to market, having good branding around it. Got some help from Damon. Trademark side of things, Matt? What do you have to say?
Yeah, I mean, he's registered. So Lucy is registered in the hand tools category or the digital tool category. So optical apparatus, namely reflecting artist tools used to aid drawing and or painting.
Okay, got it.
So he's registered.
Mm-hmm.
Oh, go ahead.
I was saying, using names, right? Kind of this, Lucy, yeah, maybe as long as it's not too close to the word lucid, maybe. And do you have any issues with using a pronoun for trademark?
No, there really isn't.
Okay.
I try to get clients not to do stuff like Lucy, just because, I mean, at the end of the day, like if clients are going to search for your product and they're starting their sentence with Lucy, their Google search with Lucy, it's going to take a little bit extra effort to get them to where they need to be to find you. Yeah. So that's the only reason I don't like it, but that and you're competing with a lot of other Lucy applications, registrations at the USPTO.
Yeah. And interesting. I'm thinking of this question here live. We have, bold, obviously we've got all capital letters.
Yep.
Have you seen any distinction when someone does all caps versus some lowercase?
Yeah.
Any considerations there?
If they're all caps, then a trademark attorney did it.
Why is that? Okay, this is good.
Yeah. So, I mean, when I talk to clients a lot, like I'm constantly when I'm referencing a trademark as a trademark. So, when I'm talking about bold patents, just in passing to a client, right? I'm going to talk about bold patents, capital B-O-L-D, patents. So first letter capitalized, right? Name of the business.
Right.
When I'm talking about the bold patents trademark, right, and talking about bold patents as a brand in terms of like the trademark itself, then I'm going to use all caps. And that in our world, in my world, when I talk to another trademark attorney, they know what I'm talking about. I'm either talking about the business or I'm talking about the actual trademark, right? When it's caps. So we always capitalize the applications for word marks at the USPTO. And you don't need to do that. It doesn't matter from a use perspective, enforcement perspective, but I guess that's the professional standard is caps for trademark applications.
There you go. So sort of an inside baseball. No need to put quotes, no need to asterisk or superscript things. So if it's if it's in caps, then it is your designation. That is the registered mark.
Yep.
Itself.
Yep.
Cool.
I've seen the USPTO change it too for other clients in the past where they'll actually go in and maybe, instead of doing like how you would normally write something out, they would do all caps for clients and stuff like that. But
yeah.
Awesome. Good question though.
Good. Well, Matt, thanks as always for being with me on this program. We covered a lot, some updates here from the USPTO, talked fees. If you have more questions about that, give us a call, schedule some time with us. We have a free discovery call. We'll get you set up for a consultation, learn more about how best to use those precious dollars you've got toward the best application possible, especially with fees going up. Don't just do it on your own. Don't waste your money. Do it right.
Yeah. Unfortunately, with these fee increases too, it's going to require us to be even more on top of clients because there's just that much more at stake. It's one thing where clients like, I don't mind spending $100 to get an extra 2 months of, time to go to market or whatever. Right. But now it's 200. They're going to start, they're going to push back more on that. So that just means that we as attorneys, specifically trademark attorneys, have to be more proactive with our clients, which is a good thing, but clients drag their feet and it's going to be expensive.
100%. There's our link for the Bold Inventor Kit. We're broadcasting that across our YouTube channel as well. That'll give you access to the whole book right behind me. Bold Ideas and Inventor's Guide to Patents, as well as our tutorials on applications and searching. So click on that, schedule some time with us, give us a chat. If you missed us, we're live every week, Wednesday at 1:30 Pacific, 4:30 East Coast. And we're off to a good start here in season 4. Thanks again, Matt. Thanks, everybody. We'll see you next week. Go big, go bold.
Go bold at boldip.com.